Hi, everyone. I'm Andrew Gradman. To make sure you're in the right place, this is Falcon, Rappaport, and Berkman's webinar series on the employee retention credit. My presentation today, entitled Three Big Ambiguities in the ERC, Partially Suspended Due to and Government Orders. I'm going to count to 20 in my head to let everyone get their coffee, get seated. And I'm not going to use Mississippi. I'm just going to count to 20 real quick. All right. I didn't use Mississippi. So let's get started. Quick words about who I am. This is me. I'm a tax lawyer. And as I've mentioned, my colleagues Matthew Rappaport and Matthew Foreman are also doing ERC presentations. If you know about our firm, we are a full service firm with a full service tax department. And ERC is just one of the many topics we love discussing. This disclaimer says that this presentation is not legal advice. And now I'm going to start with the content. So I chose to carve out a specific slice of ERC related topics. I think it's interesting that in the press and in other areas, we hear a lot of people talking about the ERC as an area rife with fraud. Which is true, and yet I think it's interesting that when we see litigation in court, certainly the IRS would be well advised to prioritize the fraud, but there are other areas that are not about fraud that make this an interesting area, and that could lead to conflict between the IRS and taxpayers. And what I have in mind is genuine ambiguities in the statute, which have never been fleshed out yet and will not be fleshed out with any certainty until a court of law rules on them. My focus in this presentation, and I believe the focus of our series of presentations, is not so much on taxpayers who are planning a new claim for the ERC, although we help with that service. But of course, there's been a sea change in the way ERC is being handled. The IRS has put a pause on processing claims, and there's been a lot less enthusiasm about filing new claims. So our attention now is shifting to people who have filed claims and who want to know where to go from there. Of course, the IRS released a process for withdrawing your claim. Matthew Foreman discussed that in his last presentation. But with that in mind, with that audience being more the focus, that shifts the sort of posture of the lawyer giving advice. And that's what I am sort of getting at on this slide, is that when you talk to a tax lawyer, the advice that they give is going to vary depending on how you're going to use it. In my daily life, I'm usually what we call a planner or a transactional tax lawyer. And in that space, we tend to be a very cautious bunch. We also tend to make fun of litigators. And I do that, but I realize I can't do that on this slide, on this presentation, because I work with litigators and this is being recorded. But generally, in a sort of euphemistically, I find them to be more open-minded to creative arguments. And so, whereas I might say to a client, look, here's a possible argument, but you might not want to make it because it's uncertain. When you're in court and when the IRS is breathing down your neck as a litigator, you're like, let's throw everything against the wall and let's see what sticks. So you're going to hear me in this presentation be more open-minded to those kinds of points, because when you're defending yourself in an audit or a court of law, you need to make every argument you can. Okay. And another issue of levels of confidence, or another issue where we ask, how is the information being used? We want to know whether the issue is how much tax will I pay versus will I owe penalties? And the reason that's important is because to get out of a penalty, the standard is a bit lower. You just have to be not too crazy, or the technical term is you have to have reasonable cause. You have to have, now you have to, for reasonable cause, you have to have been given the advice before you filed your tax return. So I may be saying a lot of very helpful arguments here, but query whether you can make a reasonable cause argument should you be audited. If the IRS says those are all great arguments, but you can't document to us that you were thinking about those things when you filed the claim. Okay, so that's why that's why that's not the only standard for getting out of penalties. You can also get out of substantial understatement penalties by showing a substantial authority for your position, which is to say, no matter what you were thinking, no matter whether you were thinking this at the time or not, having a good argument and having support for your argument can get you out of a penalty. Substantial authority, some people call that a 40% chance of success. And I like people to bear that in mind because that's less than 50, meaning, it's less than that. It may be more likely than not that you're wrong, but you can still get out of penalties on a substantial authority argument. So that's why, for these two reasons, we're going to talk about some wacky stuff today. Okay. Here's a little cheat sheet for the employee retention credit as to what authorities apply when. A lot of people don't think about this. I think it's really important to bear in mind when someone talks about the ERC, there were three regimes. There was the Q1 through Q4 2020 regime, which is everything from CARES Act and Relief Act 206. A different legal regime came in place for Q1 and 2 of 21, which implements the Relief Act Section 207. And then just for one quarter of Q3 of 2021, we had Internal Revenue Code 3134. And so anytime someone tells me they have questions about the employee retention credit, I always ask what quarters. It's like asking three different legal questions. Here's a larger statement of authorities. This is just one I've been accumulating in my own notes for all this time. I may have missed something, but I felt it was comprehensive when I compiled it. And you can see that highlighted in green are those three statutes. And then highlighted in yellow is this creature that gets a lot of attention. Notice 2021-20. It is it's not the only interpretive document that the IRS has released, but it's the big daddy of them all. And when you want to be an expert on this, you do want to study the FAQs which preceded it. You do want to study certain notices which came after it. But most substantive content to become a quasi-expert is going to be in this notice. Now, I'm going to come back to that a lot, though. Here is a quote of what I would say is the relevant text that is going to form the basis of our conversation today. It is the CARES Act. The operative language is in Section A with definitions in C, and I have another definition from D. Let's not talk about this. Let's look at my paraphrase. This is how I sketch in my own notes, I generally sketch taxes and credits and deductions to look like this. You break it out by taxpayer and amount and which tax we're talking about. So here's the ERC. It is a credit. Which tax is it a credit against? The FICA tax on employers for old age and disability insurance, which is the 6.2% tax. It's also for the railroad insurance, in case you've got any railroad taxpayers out there. The taxpayer who benefits from the credit is an eligible employer. That's the defined term. And the amount of the credit is 70% of qualified wages, as described on the screen. I don't spend a lot of my professional time immersed in a definition of qualified wages. I find that in a well-oiled machine, the taxpayer may have calculated that themselves. They may have done it with a CPA firm. It's a spreadsheet function. And it's a very mathy function. I spent a lot of my time dwelling on the definition of eligible employer. And the next slide is my outline of that definition of that term. An eligible employer is an employer, which can be treated as a single employer under the rules for the work opportunity credit or the affiliated service group rules. It's a fancy way of saying that there are ways of making multiple employers into one, and a lot of fraudulent claims have made it under the radar because people weren't following that rule. It's an important rule. This employer had to have been carrying on a trade or business in the calendar quarter for which the credit is determined, and then either of two tests must be met. In reverse order on the screen, one of them is a gross receipts test. It's an objective test. And I'm describing this the original CARES Act provision is modified by Section 207. I'm going back to refresh my 207 of the Relief Act. The text differed prior to the Relief Act, and so again, this relates to quarters 1 and 2 of 2021. Keep that in mind. But in any event, it's as so modified. That prong of the test is gross receipts are less than 80% of the same calendar quarter in 2019. I'm not going to go into that today either because it's objective, and you can generally measure that from your spreadsheet. Where people get tripped up or where legal issues arise is in this other prong of the test, where you fail the gross receipts test, but you're still hoping to sneak by, and so you say, well, okay, maybe I passed this other test. And I've isolated that highlighted text on its own slide here, because this is what we're going to talk about today, and the only thing we're going to talk about today. Operation of the trade or business must be fully or partially suspended in that quarter due to orders from an appropriate governmental authority limiting commerce or travel or group meetings for commercial or social or religious other purposes due to COVID-19. And this should ring a bell because this is the title of this presentation. That's why you're here. So now how do we interpret that term? Not a lot of interpretive authority in the statute. And the IRS came out with Notice 2020-21, which does purport to interpret it. Before we get into the content of that, I want to give a shout out to a recent tax note article by Leo Unzaitik and Jamie Vasquez. The article was timely, but Leo was not. If you know German, I think his name means untimely, but the article is very timely. And to summarize it basically says, hey, Notice 2020-21 is not law. It's merely a persuasive authority, which a court may consider or ignore in interpreting the ERC statute. And this isn't a rocket science conclusion. It's not like they solved Fermat's last theorem and revolutionized the tax law, but they did open people's eyes to something that many people aren't paying attention to, which is that, as the excerpt says in greater length, for this to have been law, the IRS would have had to have complied with the Administrative Procedures Act, and they did not. So what that means is that it is, as I say at the bottom, I add a couple of observations. If the notice says something which is taxpayer favorable, I view it as like a revenue ruling, which is to say this expresses the IRS's position on the issue and it binds the IRS, and therefore, if it contains anything taxpayer favorable, we can rely on it. I don't have a citation for that point, and I may have stumbled over, I may have not precisely expressed a distinction between a notice and a revenue ruling, but you should definitely use the taxpayer favorable stuff. Don't be ashamed to use it, even though you're not using the taxpayer unfavorable stuff, even though you intend to challenge that in a court of law. And then I'd also say that if your goal is to refute penalties rather than to take a position as to substantive tax, you could also use this document to show in your favor if you abide by the document. You could show a reasonable basis or substantial authority. Remember, substantial authority was that 40% thing I talked about earlier. So if you take away one point from this slide, it is that for the rest of this presentation, keep in mind, Notice 2020-21, this big ominous cloud that we carry with us and that we always cite to, it's something that the tax court is not necessarily going to defer to should a case come before it. So I'm happy for these guys that they expressed that in a public space in a well-written article. So now let's turn to the first of the three terms. And before I actually dive in, I forgot to mention, in terms of questions, I'm told that there's not a lot of people here. And so rather than carve out designated time for questions and answers, I'd like to invite any of you who has questions to email me after the presentation, and I'll be a good sport and I'll communicate with you. I hope you find that to be a better engagement, but it means I can fill up this presentation time and cover more material. Thanks for understanding that. So my email address will be everywhere. You should be. We'll get to that later. So So on the subject of fully or partially suspended. So at the top, I give you a little bibliography of the authorities come from that. And as you read the Q&As of the notice that I just mentioned, you'll see that the IRS has sat around a table and sort of thought about there being three kinds of full or partial suspension. One is a workplace that is completely closed, but you have like something like telework, which in their phrase is comparable operations can continue. And that's an easy case. If your telework or other substitute meets the comparable operations standard, you're not fully or partially suspended for purposes of the statute. So that's an easy one. We're not going to talk about it anymore. Another example is when a portion of a business is completely closed, as described in these examples. I'm also not going to make that an emphasis of the presentation today. The third concept, which the IRS finds, is I think a portion completely closed. I think they come up with the figure of speech. I'm going to change slides to refresh my memory. More than a nominal portion. I think that's where they come up with a legal standard. Okay, portion of your business is closed. It's got to be more than a nominal portion for us to call it a full or partial suspension. And I think in that context, they come up with a 10% test. But then they come up, but out here, there's a third, these wise people come up with a third way in which a business may be full or partially closed, namely, no portion of the business is completely closed. So we're not in the previous framework, but operations are modified in a way that causes more than a nominal effect on business operations. So here's the excerpt that provides for this. So you can see in the highlighted in green, they're saying if all but a nominal portion of the business may continue. To paraphrase, they're saying if we do not meet the standard that more than a nominal portion of the business is closed, but if they're still subject, if the business is still subject to modification, you can still have a full or partial closure if it's more than a nominal effect. I want you to keep those phrases in mind and distinguish them because it's easy to blur them. So I'm going to just say them aloud and you can write them on a flashcard if you wish. More than a nominal portion or more than a nominal effect. More than a nominal portion is like having an amputation. The business, 10% of the business is gone. More than a nominal effect, nothing's been amputated, but something strange happens. The business, you can't sell a particular product anymore. We'll see this in more detail in the next slides. I think for purposes of understanding how the IRS thinks about this, it's important to bear in mind that the concept of the more than a nominal effect test originated in earlier FAQs. And then when the IRS sort of codified those FAQs into the notice 2020-21, they expanded on those. It's always interesting. It's always important and interesting to keep in mind changes of that kind because that gives you some rare glimpses into the psychology. And that's why in this next slide, I point out that the notice 2020-21, the IRS said, we need to clean up this concept of more than a nominal effect. And so they added Q&A 18, which says that the kind of modifications that we mean are those required by a government order as a condition of reopening a physical space. Example of the modifications include, and they give a whole list. And at the end, it says, or requiring employees and customers to wear face coverings. Now, I know we're in litigator mode, meaning we're in spaghetti against the wall mode. So I will say charitably that I know of some people who think that this means that if you have to wear face coverings, you therefore have shown that you've passed the more than a nominal effect test. And I think by my tone, you know how I feel about that, but I am an advocate for everyone, and I want everyone to be, I want all the taxpayers to win. So I'll just leave it at that. But I think that's ridiculous. You have to show they're saying that in order to show more than a nominal effect, you have to take elements such as face coverings, changing the format of service, social distancing. You take those, you add them together, and then when you've shown all of these burdens, you have to show that taken together, they cause more than a nominal effect. At least that's what I expect the IRS to argue in the face of that spaghetti onslaught. So let's see, how else can we explore? What is the meaning of more than a nominal effect? What else do we know? Well, again, I'm going to give you some material here from the FAQs, which got adapted into the notices. I want to emphasize, as the authors above pointed out, all of this stuff is just the IRS expressing its opinions. When you go to a court of law, I think we could split hairs as to how persuasive this is. I think if the IRS comes up with a very coherent body of interpretation, the courts may be very deferential and say, hey, you did a good job there. We're willing to adapt that. And that's sort of a little bit beyond my knowledge of administrative law. It's an important question to have. But I think generally we can proceed on the premise that this is all just private internal things that the IRS feels, and certainly not binding on tax courts. So they give a few examples. And if any of you have worked much in the ERC space, these examples, we live by these examples. I print these out, I put it under my pillow, I take it with me on walks. I mean, these may just be examples to you, but this is all we've got. This is important stuff. Example 2 of FAQ 34, which appears in Q&A 17 of the notice, involves a restaurant. The government requires that for sit-down dining, all tables must be spaced at least 6 feet apart. And then we're told that under the facts and circumstances, the governmental order restricting the spaces of tables limits the employer's indoor dining capacity and has more than a nominal effect on its business operations. The FAQ concludes that the employer's business operations are considered to be partially suspended because the governmental order restricting its indoor dining service has more than a nominal effect on operations. I'm not going to read all these comments, but it was important for me to read just one because I want you to notice something. And this vexes tax attorneys everywhere and professionals all around the world in the country, which is that we are not really told much about this restaurant. We are not given like a lot of details about the revenue per day and the spacing between the seats and exactly how the taxpayers are burdened and the restaurant's revenues suffer. We're merely told in 2 consecutive sentences, first, that the order has more than a nominal effect. Therefore, we have partial suspension because the order has more than a nominal effect. Let's go back to our spaghetti factory here. You could argue that this is authority saying that when restaurants must restrict spacing of their tables, therefore, nominal effect, more than nominal effect. And I think that's one way of doing it. I think what the IRS might say in response is, no. We weren't saying that the conclusion that there was more than a nominal effect arose from the facts provided. This was a conclusory statement saying that had you known this restaurant better and looked at all the facts would have reached the threshold to lead to a conclusion more than a nominal effect. But you can't just, we haven't given you enough information to judge one way or the other. Now, this is true of all the examples here, which leads to what I hope is my next slide. No, this is the next slide I want to say. These examples are useless. I don't know why the IRS bothered providing these examples. I mean, unless they wanted to say that in case you weren't aware, spacing of tables is the kind of thing which in some circumstances can be more than a nominal effect on a business. I mean, that's a bit of a trivial conclusion. And I think that to have these lengthy examples is a bit tedious and misleading. And so it's really kind of unfortunate because I think it is misleading for a lot of people. A lot of spaghetti has been wasted on this. Let's see what I wrote in here. I talk about ambiguities. I also, here I talk even further about the ambiguities in these examples, but I'm not going to do that in today's presentation. So that's what I call the facts and circumstances test for whether there's been a more than a nominal effect, which is, I mean, when I say facts and circumstances test, isn't that what the statute? What else could there be? The statute says there's got to be more than a nominal effect, or excuse me, the statute's got to be full or partial suspension of business, and there's no definition of it. And the IRS has basically attempted to interpret that, and as I've expressed a second ago, has abdicated its efforts, didn't do a very good job. Now, in the notice, the IRS did additional things to sort of try and improve its description of more than a nominal effect. You know, again, pivoting from the FAQs the notice was meant to sort of clean things up. And one of the things they did in Q&A 18 was they added a new safe harbor for establishing nominal effect. This provides that the standard will be met any time where a governmental order results in a reduction in an employer's ability to provide goods and services in the normal course of the employer's business of not less than 10%. And it gives these examples. Occupancy restrictions at a restaurant. Yeah, I know, or an occupancy restriction at a retail. I mean, examples are unhelpful. But hey, what a great idea, this 10% test. I mean, if you, I'm going to lose this slide. I'm going to regret doing this. But if you go back to the definition of the ERC, it's sort of like, remember, the original test was that you could either do gross receipts, are less than 80% versus the same calendar quarter, which was an objective test, or you had this other amorphous suspension test, and the IRS basically threw up his hand and said, let's just do another, I liked the gross receipts test. Let's sort of pretend that that is what this is. So it's just another objective numerically measurable test. Before I get into criticizing the content of this, I want to just repeat, as I've said many times, because this is in Notice 2020-21, its compliance is optional. But I also want to point out, too, that because this is a safe harbor, anytime you hear the phrase safe harbor, here's an amorphous test, but here's a safe harbor that can prove compliance, that's taxpayer favorable. We think of this 10% as like, oh, I have to sweat it, I'm not going to make 10%. But this is just like, if you can make the 10%, then that's belt and suspenders. If you can't make the 10%, then you go for the facts and circumstances test. So let's, for those of you who are lucky enough to think you can make this 10% test, here are some more difficulties. What is the ability to provide goods and services? In one place in the notice, the ability to provide goods and services is measured using gross revenue. And I think many of us sort of intuitively do that. I think in the restaurant example I mentioned above, they talk about sale of food and services from the employees. And I think, but I've seen, but what happens if you do crunch the numbers, you fail the test? Can you switch to some other measure? Gross profit, profit per unit of inventory, profit per employee. Look, we're in the spaghetti mode here. And I think you should keep in mind that may be, if you failed the 10% test using gross revenue, heck yeah, you'd better check whether you can come up with an argument that your ability to provide services has been compromised by 10% using some other measure. And I've also had clients who've tried to use different measures for different business segments. That's quite a spaghetti. Difficulties in applying the safe. Okay, next one. How do you measure reduction? Because it says it has to result in a reduction in ability to provide services. Are we talking about reduction versus a recent comparable time period, or is it a reduction against the current time period imagined without the government order? Now, maybe your intuition may say, hey, it's a recent comparable time period, of course, because that's the most measurable. But look, causation, when you have a tort case and someone has an accident and you have an expert to say, okay, I want damages. The damages are, if the person hadn't had the injury, what would he be earning today? And then it's that delta that shows that you've had a reduction in income. And so that would suggest that maybe you argue it from the current time period. That would be laborious. That would involve a lot of experts. And as Guido Calabresi suggested in his legal and economic analysis, Cost of Accidents in 1970, it's one of the problems with the American legal system. But hey, the IRS wrote due to, and due to opens the door to but-for causation and expensive legal experts. So, that's the thing to keep in mind. I think this is a similar argument on the same front. What's the meaning of the phrase normal course of business? Results in a reduction of the employer's ability to provide services in the normal course of its business. Again, if you fail this test, come up with an argument that, oh, apples and oranges, this wasn't the normal course of business. I have to imagine a normal course of business. After all, in the normal course of business, the premise is that the normal course of business was modified by COVID. So, query what that means, query whether you can exploit it. And then not less than 10%. I have seen cases where people don't pass the 10% test, where using the denominator as all their business operations. But then they say, look, we have 8 divisions, and in this division, we've have a more than 10% reduction. I'm just going to say that I've seen it because I've seen people try to do that. Okay, I've spent all this time talking about the full or partial suspension issue. That relieves us with the question of due to government orders. Government orders. What is a government order? I will say this. The statute says government orders, and it specifies of the kind. Then there's been a lot of efforts to be very expansive in what counts as a government order. You'll see a lot of tax opinions, a lot of purported pro-taxpayer opinions that say, oh, here's OSHA has said you should do certain various things, and those are government orders. Now, Notice 2020-2021 contains some elaboration on what constitutes a government order. As I've said before, you can ignore it, or you should be aware of it, but you shouldn't feel too burdened by it. But I want to say, in fairness to the IRS, they came out with generic legal advice memorandum 2023-007, which I described. I think these are all quotations from that. And I was impressed that they show that the OSHA rules, in their view, are not orders. They do it without citing 2020-21 as an authority. They do it based on interpretation of the statute. So you're going to have to wrestle with their interpretation there, because they used kosher authorities. If you want to show that OSHA is an authority, you got to get around this notice, which was just issued, I think, a week ago. GLAM is what it's called. You got to get this GLAM. Now I'm getting into the due to, which I think, last but not least, but I think it's, in some ways, I think it's the most interesting, intellectually interesting of all of these topics. So first of all, what are we getting at here? The government orders have to be the cause of the partial or full or partial suspension of business. That is explored, by the way, in the interpretive parts of this GLAM that I just, if you want some discussion of it, it's in there. But basically, I'm going to give you an example of what I felt was a sound analysis that I gave to a client, because we had a client that had a food processing factory, and the city comes in and says, you need to space more. You need to do all sorts of different spacing to keep your food processing people further apart. And then that became an order that was imposed on them. And then it reduced their productivity because they had fewer people on the production line working in a less effective way. And I say, hey, look, this is analogous to the example involving the restaurant where they have to space their tables apart. So I felt like that, with some other, whipped cream on top and a cherry in the fact section, was adequate. I see a lot of analyses that just omit or are very inadequate on this causation factor. What do I have the next slide? Okay, I'll come to that slide in a second. But you know what I think is really interesting here is this due to, because I alluded to it earlier. Causation, I don't know off the top of my head of many other examples in the tax law where this is an element of a tax claim. And it takes me back to some non-tax issues from law school. Falsgraf, the case in which Cardozo generated the idea of proximate cause. It's like, yeah, I know the bomb, and I know an explosion went off on the railway train and it knocked some scales over and it hit this lady on her head on the other side of the track. But to paraphrase, we want the causation to be of the kind that is generated by the accident. And so he therefore added into the tort test, we have cause and we have proximate cause, a more limiting pro-defendant form of causation. And it's interesting because, to take that to the employee retention credit, there are so many to say that the government orders caused a reduction in business. There's a stream of business, if you want to use the analogy. There's a flow, a river, and of course the government orders are keeping people from going to business, from consuming, and it goes down the stream. So of course, as a matter of but-for causation, the most simple scientific causation, of course the government orders caused the reduction in the business. That's trivial. And so clearly the IRS is looking at this statute thinking, oh shit, we need some kind of approximate cause filter. And so in the notice 2020-2021, they generate some of that. So they here's Q&A 13, but I actually have a slide which repeats the content. This slide gives you Q&A 12 and 13, which in my understanding, are the two best notice Q&As on the subject of causation. The first one is taxpayer unfavorable, and the second one, and Q&A 13 is taxpayer. Actually, I got it backwards. Q&A 12 is pro-employer. Q&A 13 is anti-employer. And it basically, without trying to reenact these Q&As here, the IRS tries to carve up the world of causation in a way that gives it its own a form of proximate causation that it's happy with. This is fruitful ground, I think, for challenge in a tax court case, because you go into the tax court and all you have is the word due to. That's what the statute says, and the IRS is not entitled to its conclusion in here's Q&A 13, and I found it interesting, so that's why I featured it in this Q&A. It says, if a governmental order causes the customers to stay at home or otherwise causes reduction in its demand for the business's products and services, and the business responds to the lack of demand by suspending some or all of its operations, is the business considered to have a suspension of operations due to a governmental order? Answer, no. That's not how I learned it in physics class, but okay. No. An employer that suspends all or some of its operations because customers are subject to government order is not considered to have a full or partial suspension. This hits a lot of clients, and it impacted some of my clients in the dental space, where they weren't dentists, they were suppliers to dentists. The dentists had their businesses shut down. And the question is, okay, I can't sell my stuff to dentists because the dentists don't have any business and they're all staying home. Why can't I have an ERC claim? And I've always understood that under the notice, those suppliers are screwed because the IRS takes the position, quoting myself here, takes the position that the chain of causation gets broken when other people stand between the taxpayer and the direct brunt of the government order. The employer must point to how the government orders impacted the company's actual operations rather than that company's client's operations. That's what the IRS says in notice in Q&A 13, and I would love to see someone make some headway against it. Wow, we're at the end of this. I want to ask my colleagues how much time. Well, I better know what time it is. It's 9:39. I guess I moved pretty quickly. So although I said I would not be taking questions, I am. So let me see if you all. I haven't given you a lot of time. I realize that. So if you all have questions that you want to put in the chat, I'm pulling up the chat. But while I'm waiting for questions, I'll keep talking so you get your money's worth. I think one subject which I broached on in this presentation, which I find is of great interest, is let's go back to the beginning. This subject of levels of confidence, especially taxes versus penalties. It's become something. Often when I meet with clients, I make it part of the initial conversation before I render any advice. There have been a lot of, I'm going to say, high-profile examples where tax professionals render advice for penalty purposes, but the audience listening to them doesn't know that distinction and thinks it's for whether they owe the tax. And what I find interesting about that is, like, if you're a taxpayer who's highly liquid, you just got a lot of cash lying around, you would be fine with a situation where you sort of gamble on the tax. You don't pay the tax. Maybe you play the audit lottery. You gamble on not getting caught. Maybe you do get caught, and then hopefully, if you can get out of penalties, then what do you owe? You just owe the tax, and you've gambled on the audit lottery, and so an expected value is like, hey, I'd love to gamble. Now that's if you're a highly liquid person. The IRS comes back to you 3 years later, says, hey, you owe the tax. You're like, no problem. Here's a check. But not everyone's like that. Some people, they get the money, they spend it on a yacht, and they have no liquidity. The IRS comes back 3 years later, you owe a check, and and those are the people who are prejudiced and harmed when they hear advice for penalty avoidance and thinking it has to be, you have a 40% chance of winning. Well, if they understood that was what was being told, maybe they wouldn't have taken the gamble. I am seeing no questions in the question box. If you're here listening, just say something. Just tell me hi. Someone say hi. I want to know this chat box works. And then I'll let you go. That's suspicious. Oh, I'm looking in the wrong box. Hello. Thank you. Okay. Abby, how do you feel about the fact that I hit that I hit 41 minutes? Is that sufficiently long? Are we on a constraint to reach a CLE constraints? Hi, anonymous attendee. Thanks for the kind words. The only reason I'm reluctant to wrap this up, folks, right away is I want to hear from my colleague as to whether your ability to get CLE credit is going to be prejudiced. The course is not CLE approved. All right, guys. Well, I have good news and bad news for you. The good news is class is letting out early. The bad news is you're not getting any continuing related education. But my email address is in the presentation, agradman@frblaw.com. If you attended this presentation, please reach out. That's for the people who attend live. If you hear a recording of this, I'm not going to say no, but come on. I mean, you didn't attend live. All right, folks, I'm wrapping this up. It's been a pleasure speaking with you, and good luck to all of you.